Be ready. Start. Per Section 13 of the Copyright Act, copyright subsists in a. Original literary, dramatic, musical, and artistic works, b. Cinematograph, films, and c. Sound recording. The copyright claimed by the plaintiff being in a book authored by the defendant number 3, the same will fall under the category of literary work. However, for a copyright to subsist in a literary work, it has to be original. The word original does not mean that work must be the expression of original or inventive thought. Copyright Act is not concerned with the originality of ideas but with the expression of thought, and in the case of literary work with the expression of thought in print or writing. The originality which is required relates to expression of the thought, but the act does not require that the expression must be an original or novel work, but that the work must not be copied from another work. The words literary work cover work which is expressed in print or writing, irrespective of whether the quality or style is high, b. the commonplace matter put together or arranged without the exercise of more than negligible work, labor, and skill in making the selection will not be entitled to copyright. C. The word original demands only that the work should not be copied but should originate from the author. D. The court has to see whether the work is a result of skill or expense, and if finds it so, it is entitled to be considered original and to be protected against copying. E. Copyrighted material is that what is created by the author by his skill, labor, and investment of capital. Maybe it is derivative work. And F. The courts will have to evaluate whether derivative work is not the end product of skill, labor, and capital, which is trivial or negligible, but substantially the courts need not go into evaluation of literary merit of derivative work or the creative aspect of the same. Further, the content of what is original has undergone considerable change from the previously applicable sweat of the brow doctrine to the modicum of creativity standard. It was held that while under the sweat of the brow doctrine, copyright was conferred on works merely because time, energy, skill, and labor was expended. Now, under the modicum of creativity standard, not every effort or industry or expending of skill results in copyrightable work, but only those which create works that are somewhat different in character, involve some intellectual effort, and involve a certain degree of creativity. Applying the law aforesaid, it cannot be said with certainty at this stage whether Chapter 7 of the book with which this suit is concerned constitutes an original literary work or is merely a reproduction of the case files of the crime and its prosecution. If it turns out that it is merely a reproduction with no innovative thought and creativity, it would not qualify as a copyrighted work. The plaintiff has not produced before this court the said case files with which a comparison of Chapter 7 can be made, and thus the plaintiff cannot be said to have a prima facie case as the defendant number 3, through whom the plaintiff claims, cannot be said to have a copyright. It is in this context only that I had enquired from the counsel for the plaintiff whether the investigating officer of a crime and prosecution has any copyright in the charge sheet filed and stroke or investigation done. In my prima facie view, the investigating officer has no such copyright, and if narrates the same in print or otherwise elsewhere would not have a copyright therein also. Per Section 14 of the Copyright Act, copyright means the exclusive right to do or authorize the doing of acts mentioned therein. With respect to the literary works, the exclusive right is to inter alia reproduce the work in any material form and to make any cinematograph film in respect of the work. Thus, even if the defendant number 3, through whom the plaintiff claims were to have any copyright in Chapter 7, it was incumbent upon the plaintiff to, in the plaint, make out a case of the book of the defendant number 1 having reproduced any part of Chapter 7 in any material form and stroke or of the defendant number 2 in its web series having made a cinematographic film with respect to chapter 7 of the book of the defendant number 3. The plaint is bereft of any pleas in this regard. The plaintiff appears to have filed the suit on the assumption that production of the web series by the defendant number 2 after approaching the plaintiff and defendant number 3 to acquire rights in the book of the defendant number 1 to be itself constituting infringement of copyright, but which, as aforesaid, is not the position in law. Thank you.